Welcome to the Benefits Executive Roundtable, hosted by Dorothy Cociu, President of Advanced Benefit Consulting. Dorothy is a nationally recognized benefits and compliance consultant and group health broker. Here, you will watch and listen to industry experts who will break down the latest trends in employee benefits, healthcare reform, state and federal legislative and regulatory activities, all designed to empower executive decisions. We are proud to bring to you all new for Season 6 video podcasts. We hope that you enjoy your new video podcast format, and please forgive any audio or video imperfections. Thank you for viewing and listening.
Welcome to the Benefits Executive Roundtable. I'm your host, Dorothy Cociu, President of Advanced Benefit Consulting, and I want to welcome my guests today, Marilyn Monahan of Monahan Law Office and Ted Flittner from Aditi Group. Thank you guys so much for being here. Welcome to both of you.
Well, it's great to be here, Dorothy. So thanks for including me in this presentation, which we've got some new and exciting potential developments coming up in the HIPAA security world.
Yeah, it's great to be back and talk about HIPAA and to really see that HHS is making some changes that are really going to drive some positive things for not just for people talking about HIPAA, but for all of us, you and me, all of us that have private protected health information out there in the hands of all these healthcare providers.
Yeah, exactly. And it's really been needed for some time. Ted and I have been talking about this forever. You know, we can talk to people about they need to do this and they need to do that. But I think until, which we're going to talk about today, until someone actually says you have to do it, it doesn't get done a lot of times. People kind of fall asleep at the wheel. That's what one of my guests said a couple podcasts ago when they're talking about the Mental Health Parity Act. But I think it kind of is true here with this, because until you absolutely have to do something. So that's what we're going to talk about today. I ask you guys to be here to talk about the release of the HIPAA Security Proposed Rules. These are proposed rules, not final, in which Marilyn will talk about that, which were released on, I believe, December 27th over the holidays, which they love to do, right, Marilyn and Ted? That's what they always do to us. So it's just kind of crazy that they do that. And that was published in the Federal Register the first week of January. So anyway, it's big, it's huge, and it's something that we just need to dive into, right, guys?
Absolutely.
Okay, so let's talk about this. We've had a few changes, but not that many, really, changes to the HIPAA privacy and security rules over the years. Of course, we had high-tech, which was the big technology change in 2009, and then the Omnibus Final Rule in 2013. And then the Department of Labor released cybersecurity guidance, which was very much needed, but it finally brought the DOL into this, which made it applicable more to plan sponsors back in 2023, and then released additional guidance last year in the fall. And then in 2023, something interesting happened in the White House. The Biden and Harris administration released their national cybersecurity strategy and its plan for implementing that strategy. And then HHS, of course, released its own healthcare sector cybersecurity concept paper, which was trying to bring this point home to everyone and say this is an important thing to deal with. And that included some voluntary cybersecurity best practices and a strategy for greater cybersecurity enforcement and accountability. That was kind of the introduction, I think, to what's happening now with these proposed rules. That's my own personal opinion. That was their way of saying, this is coming, get ready for it. And, the whole point of it being voluntary, I think it didn't quite work. I'm guessing it didn't work as well as they wanted it to. So now they're saying, okay, we tried it voluntary, didn't work so well. Now we're going to come back to it and we're going to, start using the hammer and saying it's time to actually do something. Help us to help you. I guess that's what it comes down to, right, guys?
That's right.
Right.
Yeah. So, and then, of course, just this past December 23rd, was the effective date for the HIPAA reproductive rights rules. So we have all this new HIPAA activity going on, which we haven't had much at all. And all of a sudden, in the last couple of years, it's really, turned into what it is today with these proposed rules that they just released. So what I want to do is talk to you guys about this. I knew something was coming because I attend, as you guys know, the HHS OCR NIST, which is the National Institute for Standards and Technology conference every fall. They stopped it during COVID, but they finally brought it back again in the fall. And we were talking about the need, and they were talking about the need to have some rules on this stuff and why it would be so important to do that. So I knew something was coming, but they kind of talked about the fact that it was coming later in the first quarter or later in 2025. And so in my mind, I kind of put it off, and then boom, here we go. They released these rules kind of unexpectedly to a lot of people. I'm guessing that a lot of that motivation probably had to do with the fact that they knew that, the Biden administration was going to be exiting, and on January 20th, the Trump administration would be coming in, and they were afraid that some of these important rules may not get released, at least on a timely basis. So I think that's why that's my personal opinion, that's probably why they pushed it up and says, hey, we have to do something now. That's what I'm guessing. So you may or may not agree with that, but that's what I think happened. But so what I want to do is kind of start with setting a framework of sorts and getting some background sort of set up here. The Office of Civil Rights, they actually came out and said, we need feedback on this. We need to have some changes to HIPAA, to the privacy and security rule. We need to do some things, and we need to stop things like not only the healthcare sector, but also, as Ted alluded to, the broad range of cyber attacks and so forth that have gone on over the last several years. They're very well publicized breaches attacking school districts, public utilities, and all kinds of things, and putting the East Coast on, basically a standstill as far as being able to have gas and things like that. And so it became very important through COVID and through some time since then that this stuff is important not only for the healthcare sector, but for everybody, as Ted mentioned. So I think anything that they can do to protect the privacy of electronic data, right, Ted, is going to help everybody, as Ted said. It's designed to help the healthcare sector, but there's a much more broader reality to this. Correct, Ted?
Yeah, and remember that what we're talking about here is my personal health history, yours, Marilyn's, and everybody listening, watching this. It's all of us have data out there, and whether we want it to be or not, it can be shared with various different parties and business associates and so on. And at the end of the day, as you mentioned, there's an ever increasing ransomware attacks, data breaches, and so on. And I can explain later some of the reasons for that. But at the end of the day, it's our data that's being mishandled by these organizations, and we want them to do the right thing for the organizations, for their health, and the continuity of society, like the oil supply, the pipeline, a couple of years ago.
The pipeline, yeah, I think that was the big thing that really opened up people's eyes, right?
Right. That's right. Right. And so it's for continuity of those businesses, but it's really, at the end of the day, this is about our stuff. Yeah. This is our personal data. It's kind of like your credit data. I really get angry, when banks and credit bureaus get hacked, and that's my data. That's my personal credit history that
and the federal government
might be in the hands of criminals now, right?
Yeah. So all their social security numbers are out there, regardless of what we've done to try to protect it. The federal government has a breach. So what are you going to do? But the whole idea behind the release of these new rules was to try to strengthen cybersecurity and all over electronic PHI, protected health information. So there were some definitional changes, and I'm not going to ask Marilyn to get into all of them today because there are just way too many of them, and none of us have had time to really let all of this kind of soak in yet. I mean, we're still working on it. It's, it's 125 pages of regulations and so forth, and it's very comprehensive. They did, of course, put out a really good fact sheet, which really helps us and kind of tells us exactly where they're trying to go with this and what we have to do, which is a good thing, very helpful. But there were a couple of definitional changes, which are pretty simple. So I'm going to ask Marilyn to talk about this just very briefly. They removed the distinction between required and addressable implementation specification. Why are these definitional changes important, and what are those changes?
Before we get into that, can I set the stage a little bit just to make certain we're all on the same page? These are proposed amendments to the HIPAA Security Rule, which protects electronic protected health information. So it's your health information that may be gathered by various covered entities, which would include healthcare providers, healthcare clearinghouses, and group health plans and health insurers, as well as their business associates, meaning their vendors who perform services on their behalf. So that's what they're trying to do is enhance the rules that are designed to make certain that your electronic protected health information isn't used or disclosed in a way that is in violation of the rules, in a way that you have not approved, in the way that might be harmful to you. The regulations are just proposed at this stage. This is the process. They issue proposed regulations. They request comments from the public. They then go through the comments, decide which ones they agree with, which ones they don't. They may amend or not the proposed rules based on that. Then they issue a set of final rules. So it's a long drawn out process. The comments aren't due until March 7th. I suspect there probably will be a lot of comments to these regulations. I think there's going to be a lot of stakeholders who will be very interested in this. So it'll probably take them a while to go through those, synthesize those, find out which ones are viable, and then make final decisions as to what they think the rules should ultimately be.
Right, right. And can you talk about the differences between the required and addressable in the regulations?
Yes, absolutely. So as you mentioned, there have been some definitional changes that they are proposing. One of the big changes is the item that you just mentioned, the difference between required and addressable. Under the current set of security rules, implementation specifications are identified as either required or addressable. If they're required, it means every covered entity and business associate must comply. If they are addressable, it means you look at it and you determine whether or not, based on the size of your business, the amount of PHI you have, your system setup and so forth, whether or not you need to comply with this specification, and then document whether or not you've done it. Going forward, everything is going to be required. So everyone's going to have to take some steps to implement these. There's a few limited exceptions, but for the most part, it's going to be required. I think this is going to have the biggest impact on smaller businesses, which have, less complex electronic health systems. They may have fewer records and so forth. And in the past, maybe there were some steps that they didn't have to take because of their personal circumstances, and now they may have to take. Now, there's still the flexibility of approach component built into the rules. So if you're an employer with a group health plan covering 10,000 people, what you're going to have to do is going to be very different than if you're an employer covering 250 people, covering 50 people. So they do give some flexibility. They don't expect everyone to take the same steps to protect data. Although that also adds in some complexity to it, because now you have to decide, what is it do I have to do, and how do I make that happen? And that's where TED comes in.
Yeah.
Yeah, and that's I want to add to that, Marilyn, that they like to really highlight that some basic tenets in the original formation of HIPAA was that to allow for flexibility, to allow for businesses, organizations to kind of evaluate on their own. There's a lot of ways I could solve this. Do each of these different solutions make financial sense to me? Will they crater my business and just, stop it because I can't afford to do it? So there's this kind of element of practicality that was always built into it. And they also highlight scalability. So they want to allow that flexibility, and they still do. And so that's where it requires kind of even more interpretation of like, okay, well, it's like looking at your taxes. Like, okay, what do they really mean here? Can I really take that deduction? Can I not? Does it apply to me? So there's more interpretation there. And then the other thing that I want to add here is that not only is HIPAA designed to focus on the security of our records, it's about accessibility. And so we're going to talk about, that's going to come up when we talk about response plans and emergency plans. So it's not just about make sure that hackers or unintended people don't view our personal data. It's making sure that our personal data is available when we need medical care or we need to talk to, our insurer or our doctor.
Right.
Very true.
Right. Well, let me ask you another question, Marilyn, again, to help sort of break this down for people in the beginning here. As we kind of mentioned here, both of you kind of mentioned it, these new rules do require that you document in writing all of the security rule policies and procedures. And that's something that we've been, trying to hit on everybody since 2009. You have to do this. And yet very few people actually do, or they're so limited. There's just not a lot of in writing. They'll jot down a couple bullet points and they really don't have a paper trail of anything. So these new rules are, as you said, are requiring this documentation. Can you tell our audience briefly what they're required to have in writing in general? Obviously it's 125 pages of regulations, but what kinds of things are you required to have written down?
Well, you need to basically go through the rules, go through the implementation specifications, go through the standards and say, this is what they are. This is what we've done in order to ensure that we've satisfied the standards or the implementation specification, and document or specify what it is you've done and what procedures will be in place. I mean, that's very simplistic. It's going to be a lot more detailed than that. For example, if you need a response plan, you're going to have to outline what the response plan. If you've got a mitigation plan, you're going to have to outline the mitigation plan. So it is going to be a lot more paperwork, but in the end, I think that will protect employers with group health plans, various covered entities, because it will give them, two things. It will give them, in the event an incident occurs, it'll give them a roadmap for proceeding, going forward, finding solutions, but also veering into a different topic, ERISA, there's an increased focus on fiduciary responsibilities these days. And one of the things that people in my field spend a lot of time talking about is document your decision making so that people know that it wasn't just ad hoc, that you sat down, you analyzed it, you made a decision, and you confirmed that this is what the decision is. So that paperwork will, in the long run, help you.
Yes, for sure. And I know they talked about in the regulations, for example, when they released them, they talked about in detail, addressing things like threats, vulnerabilities, doing an EPHI assessment, right? Document all of these things and look at where information can be exploited. Those are the kind of things, identify those vulnerabilities, which Ted and Ted talk about in our HIPAA security training all the time. And it's something that we've been preaching for some time. Ted, I'm sure you probably have a couple comments on that.
Well, yeah, for sure on those all those different kinds of threats and so on, but at a fundamental level here, all of this idea of documenting, doing what you're writing down what you're going to do, writing down, putting in paper what you do, how you're supposed to do it, and so on, is really about running a good business. And if you don't have that, then you're kind of run fast and free, and it's not repeatable. It's hard to train people. When there's a question about things, like you don't know where to turn, if there's a change in management, leadership, the person with the knowledge left, there's no documentation behind. We've seen that so many times in different industries. And this is just a fundamental, regardless of whether it's health information or even electronic data, if you don't have policies and procedures, how are you going to run a business and have a sustainable business that can expand, right? So this is really just common sense. And it's, if you look at ISO, any ISO certification, it's anchored in policies and procedures, documenting what you did, documenting that you trained people. What did you train? Which revision number did you train? All that stuff. And, we know from all these different policies, whether it's HR-related policies, employment-related policies, you can't fire somebody unless you've got a trail that says you tried to work on the situation and tried to, you tried to resolve it in a positive way. And this is the last stop, that kind of thing. It really relates everywhere.
Right. Right. And I think the most important thing for anybody that's watching or listening to this right from the get-go is that you have to understand that one of the things, the most important thing that these rules are doing is saying it's no longer voluntary, guys. It's mandatory. You have to do it. And everything that we've been preaching for many, many years, it's now or never. You have to do it now. It's not just something that we'll put off into the future, because the penalties and HIPAA penalties are pretty severe. So just keep that in mind. Well, let's talk about, we talked about this fact that you have to do this. Why is it important to have executive buy-in on HIPAA security right from the beginning?
Well, because you need a commitment from upper management that they will support you in what you're doing. This process is going to take time. It's going to take money. It may very well require the hiring of outside service providers. So you need to make certain that they are on board and willing to allow their staff to take the time, willing to allow the expenditures to be made, willing to allow the hiring to take place. And then there's going to be implementation, training, et cetera. So it's not going to be just you can flip a switch and we are compliant. It's a process. Mm-hmm. And you need to make certain that everyone will support that process.
Yeah, absolutely. You have to have support from the top down. And this is like when we talk about training. If an idea or topic is not discussed regularly with management, with the employees, then employees know it's not important. And kids know this. If mommy and daddy say something, but they're not really focusing on it, they're never really looking for it, they didn't really mean it, right? So we have to know from the top down that this is super serious. And this is what I believe HIPAA is really saying, is that it's time now, because what's at stake here is all of our personal information, and breaches are happening so often, and there's just increasing ransomware attacks and so on, that you have to now run a good business that protects the safety of data and also the continuity of business, right?
Right.
And so why executive buy-in is really key on this is what I expect to happen more and more. I'd not be surprised if someone's going to attempt to hold executives personally liable. And this is what, Marilyn was referring to about fiduciary responsibility. So I want to echo what Marilyn's saying. It has to come from the top down. And it's just like, it was just like kids. We know that if our parents say something, but then they don't really follow up and, did you really brush your teeth? That kind of thing. They didn't really mean it. We know that, as people, we know that if they say something once, but they don't really pay attention to it and make it a focus, make it a measurable, then it's really not important. And, so executives have to be involved with this. They have to provide the resources, as Marilyn said, oftentimes external resources. And in this case, there's a lot of interpretation that needs to be done and documentation and so on. And then there's probably a lot of consulting that people are going to be calling for. In addition to that, having the top level management support this, what I expect to see more and more in industry is that we're looking for fiduciary responsibility, and insurance companies, for example, those who provide cyber insurance and E&O insurance are going to be looking more and more, how do we hold executives, the decision makers, responsible, especially if they did something that was an obvious, you didn't put in place basic security tools and so on. And, many of the breaches that have happened, there's like this obvious gap that didn't happen. And in cases it might be multi-factor authentication or data wasn't encrypted or so on, or they didn't do a proper risk assessment. And so you're going to look more and more for insurance companies and others to be, and probably, authorities to try and hold those executives responsible for these gaps. And now it's mandatory, right? So we really need that tie-in from the top.
Yes, thank you for that. Let's talk about the establishment of technical and non-technical evaluations prior to the changes that entity has within their own environment. Tell us what that means and why this is so important.
Well, the technical, it's easy to look at that, but, really from the beginning, HIPAA, highlights administrative, process, policy, and technical. So it's easy to look at the technical and say, okay, multi-factor authentication, or using encryption, or using certain specific, hardwares or protocols and so on. Those are the obvious things. And then there's the things that are completely unique to your organization. It's your administration. It's your org chart, the way you do business, the way information flows, the way you process things. Those are internal, and those are unique, and those are yours, and those change too. Right? So, we can look at what hardware changed, what software changed, what tools and so on changed. We also need to look at the people side. And that is, was there a change in the org chart? Do people have different roles and responsibilities? Did someone with a certain capability leave the company? And so now we need to change how we handle things. That affects the risk of a breach, could affect the risk of somebody not doing the business continuity things they need. How about work schedule? A lot of things can change. So for us, it's really a couple tools that could support that, and that's really looking at what's the flow of information and what's the organization of people, roles, and responsibilities, and so on.
Well, thank you, Ted. There is also a requirement for patch management policies, which is something, you guys have talked about in training for many, many years as well. But it needs to be done at least every 12 months. They're putting a time frame on this. They're saying you have to do it, and you have to do it annually. Can you tell us why this is so important, and why are this, the obvious question is, why are they asking for this in general, right? Why is this so important now?
Well, it's obvious, and among the 125 pages of this, and of course it's written like your IRS tax forms, where you got 3 columns, you got to scroll up and scroll down and scroll, in that wonderful government way. There's so much of this that is actually kind of giving the backstory of and highlighting specific different breaches and the size of some of these breaches, and highlighting again and again, like, look, companies have not been doing all the right things. So now we're going to make you do the right things for good business and protection of people's data, ours, right? Remember, this is personal for all of us, and so requiring that we do patch management, requiring that it's not just good to do, but got to do.
You know what, Ted, I'm going to ask you a simple question that I've just realized some of our audience may not even understand what patch management is. Can you just very briefly describe what that means?
Yeah, it's not about fixing a flat tire or putting on a Band-Aid. It is every software that is made by any company is modified over time, and a lot of those updates are for there was it was supposed to work the right way, but it didn't. So we gotta fix that bug. And a lot of those are security patches, security updates. And the same thing happens on hardware. There's something called firmware, that's software that just resides on the device, like a network, a switch, a piece of hardware. And so that firmware needs to be updated. The software on your computer, Windows is pushing out updates every Tuesday, right? There's constant updates. Browsers are pushing out updates continually, always pushing out updates. So patches are when we find out that, security patches, when we find out that there is a vulnerability, and oftentimes it's hackers who will find these. And, hackers, if they want to maybe get a reward, they'll put out there in the community or to the hardware or software maker, hey, I found a weakness in here, a vulnerability. You can give me a little paycheck for that. Or they'll communicate that on the dark web, to their colleagues who are going to try and find and write a script that will exploit that.
Right.
That's what malware is all about.
Right.
And so this is about making sure that software is updated and firmware is updated.
Thank you for that. One of the requirements, of course, is to have a robust risk management plan. Wow, what's so new about that, right? It's not new at all. We've been talking about that forever. But the requirement to have this, putting it in writing, and these are the new things that they've added, things that we've been preaching for many, many years. So why do you think this is important? Why should entities be doing this? And why are they not doing this, I guess, is another question, as well as they should have been all along. I mean, that's kind of a loaded question. But Ted, your thoughts on that?
Well, they just haven't been doing the basics. I mean, that's the bottom line. They haven't been doing the basics. And, some of the biggest breaches that we can look at, we're like, wow, these are just basic gaps. Multi-factor authentication just wasn't turned on. Using default passwords, using the same password multiple days. So, just like user rights administrator, using an administrator account all the time and not just for doing administrative stuff. Like some of these basic tenant things haven't been done by industry. And so now we're looking at, it's got to be robust. And the breach history just proves that we need it. So something like what we do, and we'll talk more about this, in the future. We have what's called Aditi Zero Trust protection. And that's something that, no matter what, if you accidentally click on an email and something tries to execute, it's going to block that immediately because it's not on your whitelist of allowed software. That kind of thing, that's robust. So even if people make mistakes, it's going to get blocked. And that's the kind of thing that we're going to be looking more for in industry. What we'll be looking at here is updating those process maps. And the documentation here, it calls it out. You got to update your inventory, your network map, and so on.
Right.
So this is all needed. It's all good. Thank you for finally making it required.
I know, huh? This is what we've been asking for many, many years. Well, they also added stringent requirements for monitoring and incident response, policies and procedures, and so forth. And we talked about this. Everyone here on this podcast today, we've talked about this in separate podcasts many times over the years. And now with the DOL requirement for their cybersecurity guidance and so forth, and the additional responsibilities of fiduciaries and putting it, writing and that sort of thing, and that you're liable for these sorts of things, that's really, brought that to the forefront. So I guess, I just want to mention this because before I said it was recommended. all we could do is recommend and say, this is what you should be doing. Now they're saying you need to do it, and you need to do it now. So what in general does it mean for monitoring and incident response and putting those things into policies and procedures? So Ted, let's start with you. Let's talk about, monitoring and incident response in general.
Well, I mean, at the most general level, how do we know there's a breach? How do I know something has happened? Will anybody say something about it? Will anybody do anything about it? Right? So we need to monitor, and what is highlighted in some of these 125 pages and has been highlighted in so many of the recent breaches of the last, 5 years is that there will be someone will get into the system and they'll be there for 6 months, 12 months, 20 months. Seriously, there are breaches where someone has been in the system for almost 2 years. Mm-hmm. And, it's like, what? How did we not know this? And, the longer that a criminal has to case the joint and prepare and to, get the fingers in deeper, the more likelihood they're going to take more stuff and it's going to be harder to recover, if at all. So it's really about, how do we know that someone has breached in there? And how do we communicate that? And how does that turn into a response plan?
Would this not also include internal incident monitoring, in that you have an employee who's only supposed to have access to this category of PHI, but they go surfing and look at several other categories of PHI, information they're not supposed to have, they shouldn't have access to? We've seen this happen in some hospital cases, have we not? Where, for example, a celebrity checks into a hospital and then employees who are not treating that individual then go and look around and see what they can find. Those are also, very serious breaches, and employers need to make certain, or covered entities need to make certain, that those kinds of things are prevented, if at all possible, and then if they do occur, that they're found and that they're addressed.
That's absolutely right. And the documentation here, in this case, this proposed regulation changes, it highlights that not just external, but internal, and so it's people who may inadvertently see something they shouldn't have, and it's people who are really looking to get into trouble. And the case that you highlighted, there's at least one where someone was they worked there at the hospital and they kind of down on their financial luck and they kind of could use some help, and of course there's someone outside to say, hey, give you some money if you can go and get some information about who might have checked in the hospital, right? So there's incentive there,
right?
So definitely the inside and the outside threat.
Right. Well, we've always recommended encryption since, all of the time through HIPAA Security, but especially since 2009 with high tech. Many entities do use it. Some choose not to. They use other types of what they think are acceptable protections for electronic information. Now it's required for all ePHI at rest and in transit with limited exceptions. Well, it's now required, at least in the proposed rules. We're assuming that that's probably going to continue in the final rules, and we'll see what happens in the next few months. But this requirement that they're talking about, I'm assuming that you're in agreement with me that it is the best way to protect data, is it not? That is to encrypt the data?
Well, it's a no-brainer. This is basically free security. Mm-hmm. We're really saying, just go ahead and put a lock, at least put a lock on this. It's the basic thing you can do. It's free. You just, you set that up. It's not complicated. One of the things that is changed here in this proposed regulations is some of the definitions, including like media, and storage, so they're really kind of expanding that to say, we're talking about encryption, not just where it's sitting, but also where it's being processed, when it's in transit. So it's kind of expanding to deal with the reality that 10 years ago, 20 years ago, when HIPAA was developed and has it originally, published, and as it evolved, it's more complex now, and data is more or less everywhere. It's ubiquitous. It's in the cloud and so on. So there's been some kind of updates to that, but encryption is free.
Yeah.
Do it.
I know. Why not do it? I mean, that's just, you're right. That's a great point to make, which I hadn't even thought of it that way, but you're right. I mean, that's a pretty inexpensive way to secure everything, and why people chose in the past not to do it is beyond me. But
yeah. And when I say it's free, I mean there may be a cost to maybe upgrade from Windows
minimal,
to Windows Professional, but at the end of the day, the effort involved, the cost involved is minimal, and it's really about just doing the basics.
Yeah.
Isn't this where data mapping and keeping track of your devices and where all your data is will become increasingly important, because you have to know where the information is in order to make certain all those devices, whether it's your cell phone or all the various laptops your company may have, et cetera, do have the most up-to-date software and do have things like encryption.
That's absolutely right, and more we have kind of more players. What about that AI? What about that AI tool that you're using?
Yeah.
Where does the data go? Is it out there in the cloud somewhere? Is it on some other platform? Did they sign a BA agreement with me? Do they have any clue what HIPAA is? Do they use any encryption? So more and more our data goes more and more places, more and more devices, and absolutely those data maps and understanding the inventory of the hardware and the software that's being used is critical.
Yeah, and we'll come back to that. I do want to ask about that more in a few minutes. But Marilyn, I want to ask about these proposed rules. They're requiring, again, it's proposed, but they're requiring group health plans to include in their plan documents requirements for the health plan sponsor to comply with, of course, the administrative, physical, and technical requirements and safeguards of the security rule. They want to ensure that any agent, that has access to this information, business associates and so forth, that they're doing what they're supposed to do, and that they have contingency plans to make sure that there is protection going on, that they're, at all times, again, whether it's stationary, whether it's in transit or whatever, but they're requiring this in-plan documentation. Now let's talk about this for just a moment. And they're talking about it without reasonable delay, but no later than 24 hours of activation. There are some time frames in there and so forth. From a legal perspective, Marilyn, in general, of course, just in general, I don't want to get into all the legal details here. Why is it important to put this type of information, and why do you think their idea of putting into plan documents and so forth, why is that so important from a legal perspective?
Well, there currently are some rules about including certain information about the HIPAA privacy and security rules in your plan documents. I think if these rules do get adopted as is, I think one of the things we're going to see is this just going to add another step to the compliance process. Not only are you going to have your HIPAA written policy and procedures, you're also going to have to look at your plan document, see what it says, see if it requires any updates. I suspect it will, and then determine what kind of specific detail and what level of detail you need to include in that plan document in order to comply with the rules. The reason you need it in the plan document is the plan document is the legal document that establishes and maintains the plan as required by ERISA for those entities that are subject to ERISA. And it is really what outlines rights, responsibilities, obligations, etc., and the administration and maintenance of the plan. Since this is a key component of that, making certain that the data the plan gathers is also protected, I think it is important to have some level of disclosure in that documentation, explaining to participants, beneficiaries, etc., that this is what we're doing, this is what we need to do, this is what's keeping your data safe.
Yeah, and the Department of Labor, like I said, when they released their cybersecurity guidance a couple of years ago, and then of course some updated ones this past fall, that was exactly the point of that, right? They want to make sure that the plan participants are aware of these things, and even the Department of Labor even went so far as to say, we also need you to train your employees so that they're protecting their own data. It's not just the plan document. It's not just our responsibility, but it's the employees, your production line workers and everyone else that has to be responsible to some extent for their own data, because the plan sponsor, for example, can do everything in the world. Put in encryption, put in policies and procedures, do all these kinds of things, do what they think is really secure, and then all it takes is as an employee giving away their password or putting it on a Post-it note, and then that Post-it note happens to be on a laptop, which is then stolen. Right, Ted? I mean, it's...
Seen it before.
the people factor, right? It's
Yeah, and this is really, it's about responsibility. So it's really about, making sure that things continue to stay updated, which these regulations, this proposed regulation change, highlights case studies where, things were not kept up to date. It highlights, risk assessments, and I'll just add this one, kind of the risk assessment category. Really, virtually every single HIPAA violation agreement or settlement starts with the words "and insufficient or no risk assessment was done."
Yeah.
And what's highlighted a lot of times is they did a risk assessment once, and then did lots and lots of changes.
6 years ago. Yeah.
Right. And so this is keeping documentation up to date. It's really saying we're going to make you do the right things for society.
Right. So, Ted, I just want to kind of continue this a little bit. The new rules strengthen the requirements for planning and contingencies for responding to security incidents. Specifically, regulated entities are going to be required to do a whole lot of things. And I have a whole list of stuff, which I'm not going to read, but it includes things like establishing written policies and procedures to restore information within 72 hours and to perform an analysis of the critically relevant information and, make sure that the technology assets are the highest priority for when you restore things and establishing written procedures for all of these types of things. There's a big long list of all these things that are included. And these are all things that you and I and Ted Maishiba and all of us in the security world, privacy and security world have been, again, beating people up with it since 2009. But from your perspective, what is the most important thing, related to this and why is it so important? And why do you think that they're finally saying we need to strengthen these? Ted, I think
because the number of incidents has increased so much, the size of incidents has increased so much. So when breaches happen, that so many times these days, it's in the tens of thousands, hundreds of thousands, millions, 100 million records that are breached. These are just massive, massive breaches, and they're happening with greater frequency. So it's kind of like we talk about. Well, there's a lot more storms happening. We need to think about storms, or fires happening. We need to think about fires. So it's about business continuity, just at the basic level. And we know that if you fail to plan, then you plan to fail. And, we know that if it's not in writing, then you can't train people properly. You can't practice your plans. And if you don't practice, then, how do you know if you even have the right plan? And, what happens with the stress of an emergency? Clear thinking goes out the window. I want to highlight, New York Mayor Rudy Giuliani credits his success during, the 9/11 events. He said, my secret was, for success was to be the calmest person in the room. And, really, how do you stay calm? The way they do that with NASA, and remember, we've sent people off to the moon and they're out, millions of miles from Earth. How do you stay calm thinking that you might have an emergency and ain't nobody there to fix it? And if, it's like you could really cause someone to go into a stress lock. The way they overcome that is they practiced it and they practiced it and they practiced it in simulation, so many times before they even left the Earth that if something pops up. Oh yeah, we've done this before.
It's
I've got a plan.
Memory. Yeah, it's like muscle.
Let me pull up that flow chart and I'll just go through that.
Yeah.
So it's really, you got to have it in writing so that it does happen and it does happen in a comprehensive way.
Right. And I think that's what the most important lesson to all of this is you might have been doing it. You might be doing it now. You might have been doing it since 2009. But if you didn't have it in writing, as far as the government's concerned, it didn't happen. Right. That's what Ted and I preach all the time in our training. So, Marilyn, do you have any further comments on that?
I think Ted covered it really well.
Okay. There's also a requirement to strengthen security overall that you have to implement written procedures for testing and revising written security incident response plans. And Ted, you briefly mentioned this before. What are your thoughts on this and what should be done here, at least at a minimum?
Yeah, I'll say that regardless of federal requirements, this, it's like we're talking about with business continuity, companies need response plans. It's like you need a plan for, if you live in an area where there's fires or floods or earthquakes, you need an emergency response plan. And if you don't have one, then, it's going to be, chaos. You'll roll some dice and maybe you'll get lucky and things will flow well, right? But leadership needs to treat IT responses like they do with fire and flood and so on. If you don't have a plan for that, then the fire is going to grow. If you don't have a plan to respond to an IT threat or breach, then it's going to grow. They're going to get in deeper. They're going to take more things. They're going to do more damage before they get kicked out or shut down. And so the longer they have the outsiders, whether it's insider or outsider, has with their data without authorized access, then the more likelihood they're going to do more damage and the harder to recover. So we recommend, implementing things like DD Zero Trust, which I mentioned, which just blocks stuff right off the bat, process mapping and responsibility charts and so on, roles and responsibility charts, and mapping that out. And really, at a minimum, you have to be able to stop the damage, understand it, restore, validate that you restored safely and correctly, and then go forward.
Right. Well, I want to come back to something that is really big in this, and it's something that we kind of talked about at the beginning. But in the proposed rules, there's now a requirement for a compliance audit being done annually, at least every 12 months. Again, we've been preaching that you need to do this for many, many years now. What are your thoughts on this as a proposed requirement? And is that a good thing or a bad thing?
Well, I think it's a good thing. All of this at the end of the day, I take it personally because it's my data. Mm-hmm. It's out there in the hands of companies. Whether I like it or not, there's my data out there. And one of the things that this document highlights is that health information is something you don't change. Like, I don't change my birth date. I don't change certain factors about my birth. And so that's different than, say, a financial record, which I could change my password or my address or so on, so someone's not going to hack into my bank account in the future. But my birth date, someone can always take my name and my birth date and certain health information facts about me and mess with my credit for the rest of my lifetime, possibly after I'm gone, right? So there's an impact or the size of the risk of, the impact or the risk of a PHI being breached is greater in the eyes of HHS than a lot of other information that we have personally out there. So this is super important. And, we got to make sure that since our data is out there in the hands of everybody, providers, doctors, hospitals, BAs, and so on, that remember, this is like the number one thing that's cited. I want to remind us that with the HIPAA settlements, that risk assessments, missing the risk assessment, which is the basic thing of where do I have issues? Where am I going to get caught? That basic thing, they're not being done. And so compliance, basically we're saying we're going to force you to do the right thing. And remember what I mentioned earlier, if your parents tell you something, but they don't keep following up on it, not important. If our leadership says HIPAA important, they never measure it. They never check to see if we're following the rules. Not as important as doing my day-to-day work or, whatever business goals. And so this has to be part of one of those things. Look, we're going to check and make sure, are we doing the right thing? We might even pay somebody outside to come in and say, are you doing the right thing? Right. So it's about forcing us to do the right thing and keep it updated.
Yeah. And Marilyn, as an attorney, what are your thoughts on the potential requirement of an annual compliance audit? And is that an important thing for people to take seriously?
Well, I won't really look at it from the perspective of an attorney, but just as a business person. And I'll circle back to the comments that Ted made at the very beginning of the program. And that is that things change and software changes, hardware changes, people change. And if the last person who did the risk assessment has left the company, and in the meantime, you've changed a lot of personnel, you've changed a lot of hardware, you've changed a lot of software, that's not valuable anymore. It's not really a risk assessment of your current situation, and it's not going to reflect where your vulnerabilities are and what your solutions are to those vulnerabilities. And things change so rapidly now that I think it's increasingly important that these risk analyses are done every year, perhaps more often. I'll turn to Ted on this, but I think there could certainly be circumstances where you might even have to do it more than once a year if your circumstances should change significantly enough that the conclusions that you reach, the analyses you did earlier, are no longer valuable.
That's absolutely right. In the language of it, I forget the exact words that they use, but they're alluding to if things change materially that are significant to your risk or to your process. And this applies to every one of these documents. It applies to all these documents. It says, like your response plan. If your org chart dramatically changed or you're using you have different locations, you got a new building. You need a different fire escape plan for that new building. And so they're really alluding to every 12 months at a minimum, right? More often if things really dramatically change.
Right, exactly. Well, Marilyn, these are not final rules, as we talked about a few times today. They are proposed. Can you tell us about the comment period and what that means and why it's important that stakeholders actually provide comments during these comment periods?
Well, currently the comment period is scheduled to end on March 7th. Sometimes they extend that if they're getting a high volume, but that's our current comment period. And the regulators really do read these comments and they provide feedback. When they ultimately issue the final set of rules, they'll have what we refer to as the preamble to the final set of rules, where they'll discuss, several commentators said the following. As a result of that, we changed the definition, we changed the time frame. Despite what they said, we're comfortable with what we proposed at the beginning, and so we're going to maintain that. That is a very helpful process. The regulators try their best to understand what real business practices are, but this gives stakeholders an opportunity to weigh in and say, hey, did you think about the following? Did you think about the impact? Did you think about the feasibility, etc.? So these comments can be very helpful. They can be very useful. There is a process in which you can submit them, and I would encourage those who have some real concerns about these rules, good and bad. It could be both. You could. Sometimes people write in. We say, hey, we like this. We think this is a good thing, but maybe tweak this other thing. That's fine too. So I think it is important. If you want a voice in the process, this is your opportunity to be a voice in the process.
Absolutely. And I'm always in favor of comment periods because in the past I've actually submitted during the comment periods for several things that were very important, particularly when I was in the TPA business and coming out of that and first moving into HIPAA consulting and things like that. I actually did submit comments, and I think it's a good process. People like the Ted and Teds of the world, these technical experts, they want to hear from people like you as well. So I always highly recommend that. I think it's a good way for them to see, hey, this is the reality. This is the real world. What you're talking about can't be done in the real world. What you need to do is this, because this is going to solve the problem, and not necessarily, they're not all IT professionals. They're not all, security professionals, like Ted and Ted might be. So they need help from people like that. And I think it's a good thing overall. So that's unfortunately all we have time for today. But we are going to be having part 2 on this next week. I'm going to have Ted Flittner back again next week, as well as his partner, Ted Mayashiba, also another principal from Aditi Group. And we're going to get more into the depth of the technical requirements. And I'm going to ask them a lot of questions. So hopefully it'll help all of our audience to really try to understand these proposed rules. So anyway, I want to thank you guys so much for being here today and helping me with part 1. Marilyn, thank you for everything. Ted, thank you for all your comments. They were wonderful. So Marilyn and Ted, thank you very much for being here today. I really appreciate it.
My pleasure. It's always a pleasure to chat with you, Dorothy, and to chat with Ted and learn what he has to say about these new proposals.
Yeah, and I really appreciate the perspectives that together we bring together. Dorothy, you're bringing the insurance industry and all that kind of coverage side, and Marilyn bringing the interpretation of law and interpretation of legal, employment and so on. And, really at the end of the day, it kind of warms my heart to see all this happen, because at the end of the day, this is my personal info. It's yours, it's Dorothy's, and it's everybody listening and watching. So this is about helping everybody to do the right thing.
Right, exactly. So let me ask you this. If anybody would want to reach out to you, which I'm sure people will, Marilyn, how would they do that?
Well, you might try my email, marilyn@monahanlawoffice.com.
And Ted?
Well, you can reach us at aditigroup.com. That's ADITI group.com and info@aditigroup.com.
Well, thanks again to both of you. I really, really, really appreciate you being here with me today. And Ted, thanks for coming back next week. We really are looking forward to that as well. For everybody out there, please stay safe, stay healthy, and stay tuned for the next episode of the Benefits Executive Roundtable. Thanks, everyone.
Thank you.
Bye-bye.
Thanks for watching. Stay tuned for compliance tips, cost containment ideas, new trends, and decision-making tools. This podcast is produced by Advanced Benefit Consulting, Anaheim, California. All views expressed are those of the host or interviewees and not necessarily the views of Advanced Benefit Consulting. Information contained herein should not be construed as legal advice. We always recommend that you consult with your legal counsel as situations do vary. Ms. Cociu can be reached at 714-693-9754 extension 3 or toll free at 866-658-3835. By email at dmcociu@advancedbenefitconsulting.com or visit our website at advancedbenefitconsulting.com.